as force to attempt to disarm Officer Scher.
Yes, I mean, he was grabbing onto it and trying to either pull it away or not letting go of it, not following commands.
And is attempting to disarm an officer, is that a felony under Michigan law?
Yes, it is.
Is forcefully disarming a police officer, would that be deemed an inherently dangerous felony?
Yeah, it is a dangerous weapon that's being taken from the officer, and the officer would be fearful of why they're taking it, if they're going to get used against them.
Now, for the police officer, have you seen on the video, even prior to the taser, did Officer Scher, was he already going through a physical struggle and may have been showing signs of exhaustion and stress?
Yes, you can see that in the video, just based on the breathing, the way the commands are coming out of his mouth. You can tell that he's expending a lot of energy and getting spent.
Would it be fair to say that when it turns to a suspect attempting to disarm him, that would add even more stress and fear for a police officer involved in that situation?
Yeah, that'd be a highly stressful event to go through.
We'll move into Officer Scher's use of deadly force in just a moment here, but leading up to that, does Officer Scher appear to have attempted to utilize other reasonable force options that were within his abilities at that time?
Yes.
Now, can you give just a brief explanation, Grand Rapids Police Department, how use of force situations should be evaluated?
We have to evaluate use of force situations that a similarly trained police officer with the same experiences, and then look at their decision of what force was used. Was it objectively reasonable at the time it was used? And you can't look back in hindsight. At that time, what was going on at that time when that decision was made?
And that's important, at that time, no hindsight. Is that fair
Correct.
to say?
Yes.
As someone who's been a police officer for as many years as you have?
Yes.
Now, sir, before I get into the final areas of discussion here, I just wanted to ask you a few more questions concerning other felonies that you may have observed from watching the video. Now, and actually, let me take you through something here a moment. Could you please start the video? I'm just going to take you through several slides here, okay? This is a video that we watched yesterday. It's been broken down into several freeze frames. I'd like to ask if you could just go ahead and go through these slides, and then I'll ask some questions. And what that is it's frames 7,432, and I believe it's 50 frames. Sir, is there anything training standpoint that you see remarkable, and we can go through it all and then come back again, but anything remarkable that you're noticing here prior to Officer Scher reaching for his firearm?
He's really off balance. His feet and knees are off the ground at this time. Basically just hanging on at that point.
Now, how about the suspect in his body position? Is that also changing?
Yeah, it's constantly changing throughout that, but yeah, he has a much more stable platform.
And that's reference point 7,450. Now, sir, under Michigan law, is it a felony to assault someone with a dangerous weapon?
Yes.
Now, under Michigan law, is it a felony for most persons to even possess a taser?
Yes.
Now, is it a felony under Michigan law to commit larceny from a person?
Yes.
And is larceny from a person basically stealing something from the person or from the body, taking somebody's property or something else from the person of
Yeah.
another?
That would be definition of larceny.
And the suspect here took the taser from Officer Scher?
Correct.
Sir, I'd like to get into deadly force factors within Grand Rapids Police Department. When an officer deems it appropriate to use deadly force, that it's now turned into a deadly force situation, are there various means that might be reasonable at that moment for the officer to administer deadly force or to use deadly force?
Yeah, deadly force is not limited to a firearm. You can escalate to deadly force in various different options of striking in the head with a baton or with your radio or hitting them with your car or choking someone out, limiting their airflow.
Basically, what's reasonable at that time to end the threat?
Yes.
And once the decision's made to use deadly force, you can use deadly force however is reasonable. Is that fair to say?
Correct. If you perceive that threat that would authorize deadly force, then yes, you can use any means necessary.
You already mentioned firearms. Certainly, you have firearm training as standard protocol within Grand Rapids Police Department.
Yes.
And do you train to shoot in different areas of the body depending on what is reasonable under the circumstances?
Yes.
You sometimes train to shoot for perhaps center mass area of the body.
Yeah, the majority of our training is then hit center mass, but there are many other target areas that we focus on that are available at that time.
And you also train to appropriate to shoot for the head.
Yes.
Do you train to shoot from different positions?
Yeah, we shoot from many different platforms, from laying prone on the ground, from kneeling to squatting, while moving, many different platforms.
And you may have already answered this, but just to make sure I get this point across, are officers trained to avoid headshots? Is that something that they're trained?
To avoid headshots? No.
Okay. Now I'd like.
Hey, just so everyone knows, this is an evidentiary hearing to determine probable cause in the shooting death of Patrick Loyola. In April of 2021, Officer Krister Scher, a 7-year veteran of the Grand Rapids Police Department, attempted to stop a vehicle driven by Patrick Loyola. Once he did get the vehicle stopped, Patrick Loyola refused to honor any of Officer Scher's commands. A big fight ensued as Patrick Loyola tried to escape. He ended up getting his hands on Officer Scher's taser. Officer Scher then shot him in the back of the head while he was on his back, as you saw imaged in those videos there. That occurred in April of 2021. In June of 2021, Officer Scher was fired by the Grand Rapids Police Department, and he has been charged with second-degree murder. Again, this is an evidentiary hearing, so both the state, which was yesterday, and the defense yesterday afternoon and today are presenting evidence on whether or not it was a justifiable use of force. Yeah, well, so there, now you're all caught up. Make sure you guys like and share this, especially on YouTube. We're getting shadow banned like a motherfucker.
Around it.
Yes.
And is it clear from the video that that was present here where the officer was outnumbered by the subject and the passenger of the vehicle?
Correct. There's a passenger and then another unknown individual on scene as well.
And Officer Scher, I believe we've established, was he radioing for backup on multiple occasions?
He was.
And according to the video, at least, does it appear there was no sign of backup or assistance?
There was not any other officers on scene at that time.
Now, as another factor that might be considered, subject's weapon, is that a factor to consider?
Yes.
And here, the weapon, we've discussed it already, but suspect disarmed Officer Scher of a serious weapon, is that correct?
That is correct.
And a weapon that Officer Scher is trained can cause death or serious injury, is that correct?
Correct.
Another factor, alcohol or drug involvement. Do we know now that alcohol was certainly a factor in this situation here?
We know that now. I wouldn't know that just from watching the video, though.
Sure. Now, how about exhaustion? Is that another factor to consider in the totality of the circumstances?
Yeah, exhaustion, fitness level, and
Can you just explain, just generically, in the course of training, and we're gonna get into this more, perhaps with some other witnesses, but just survey the topic.
exhaustion is one of the totality of the circumstances that need to be considered because a long, drawn-out struggle. You can only go at 100% for so long before you start depleting your energy supplies, and then your skill set starts to diminish during that time frame. For as long as it keeps going, your abilities are diminishing and depleting at that time.
And do you have scenario-based training?
Yes, we do a lot of scenario-based training.
And do you generally try to time those routines out? Only let the training officer go at a physical struggle for a certain amount of time?
Yeah, I mean, our scenario-based training is objectively based. We're trying to meet an objective. Some of them are long, drawn-out, physical altercations on a wrestling mat where you're trying to get someone in custody and we're not allowing them. Some of them are really quick scenarios, but.
And can exhaustion be intensified by stress, fear, or adrenaline?
Yes.
And are those basically just human factors?
Correct.
Now, one other factor, weather or terrain, does that appear to have been an issue here with rain and slick conditions?
Yeah, it appeared to be raining. I was out on the scene. It was raining. It was, you're in a yard that is slippery and muddy. You're not on the best footing.
Just a few more here, but another factor listed in policies, reaction time. Is that correct, that that's listed in the policy?
Correct.
Can you please, do you train your trainees about action versus reaction?
Yeah, action, it's not only a standard in law enforcement, it's in pretty much anything. Action is faster than reaction. So the person that wants to...
No, dude, DL Freighter, it's not a trial. This is an evidentiary hearing in front of a judge, not the trial. Hopefully it never even gets to that.
Do it, and then actually physically do it. So action is always putting the officer at a disadvantage, because of reaction.
Can you discuss, or I'm not sure if you show videos on the topic, but discuss scenarios as far as a suspect with a weapon?
Breaking news, Paul Pelosi was attacked inside his home early this morning. Nancy Pelosi was not there. They do have the suspect in custody. He's expected to make a full recovery.
Out and you're in a low ready position and you're dealing with an individual that potentially is armed with another gun. They can spin and raise that target and shoot at you faster than you can perceive that threat and react to it and get shots back at that lethal, deadly force encounter at that time. And it just drives home that action's faster than reaction.
And that is a concept that you train your trainees to be conscious of?
Yes.
Now, how about, as another factor, distance from the subject? Is that also listed in the policies?
That is correct.
And I believe we've touched on it, but here the suspect and Officer Scher, would it be fair to say that they were within arm's length at the end of the struggle here?
Yeah, they were wrestling tied up.
And were they within
fucking
range
tired.
of the officer
Tired
being
as shit.
used to cause serious injury or death?
Can you
I'm sorry,
rephrase that?
Were they within range of the taser being used to cause serious injury or death?
Yes.
Last factor, sir, do the policies list imminent danger as a factor?
Yes.
And you may have just answered this with your prior two answers, but we had the suspect, as you just explained, was in arm's length distance from Officer Scher, is that correct?
Yes.
And the suspect had what is deemed a serious weapon that was still capable of causing serious injury or death, is that correct?
Correct.
And Officer Scher is trained that action beats reaction?
Yes.
Is that correct? And the suspect that he was just dealing with had just forcefully disarmed him of his weapon, is that correct?
Yes.
So would it be fair to say that imminent danger was at issue here?
Yeah, that'd be reasonable to say.
Now, sir, based on all the factors present on the video, and I know those factors we discussed, there's several other human factors that come into play for training officers, is that fair to say?
Yes.
For purposes of prelim, let me just ask you here, in conjunction with the factors mentioned, in conjunction with what's on the video and in departmental policy, the suspect here had forcefully disarmed a police officer. Is that right?
Yes.
And the officer was outnumbered with no signs of assistance. Is that fair to say?
Yes.
And did the officer appear exhausted from minutes of struggling with a suspect who was evading capture with active aggression and resistance?
Yes.
Did the suspect's physical strength or size, did that appear to be prevailing when he was literally lifting Officer Scher off the ground at the end?
It appears that officer was unable to control that individual, and that may be the cause.
And the suspect had a weapon in his hand that was capable of causing serious injury or death. Is that
Yes.
right? The suspect was in close enough proximity to use that weapon. Is that correct?
Yes.
And the suspect had already fought with force to disarm the officer. Is that correct?
That is correct.
And the officer had been taught that action beats reaction. Is that correct?
That is correct.
Based on the totality of those factors, was it reasonable for Officer Scher at that time to conclude there was a reasonable threat of serious bodily harm or death?
Yes.
Thank you, sir.
Hell yeah, there was. That's what I'm talking about.
Captain, I guess I'll go through your use of force. We've talked a lot about it already in terms of, you're familiar with the use of force policy that's on the website of the Mayor's Police Department.
I am.
In terms of 9-1.1, the goals of the use of force policy, I'll cite number 1. Use only a reasonable amount of force to conduct law enforcement activities. That's on there, correct?
Correct.
Number 2, use only a reasonable amount of force to save lives, overcome resistance, and maintain an advantage. That's on the website, correct?
That is correct.
Number 3, use deadly force. I'm going to summarize this because it's quite a long paragraph, but you can only use deadly force against a reasonable threat of death or serious bodily injury, and when the officer has probable cause to believe the subject poses a reasonable threat of death or serious bodily injury to the officer or others. That would be a third paragraph in summary, wouldn't it be?
Yeah, that's part of it.
Going to 9.1-2, objective reasonableness, that's part of your policy. Objectively reasonable means using the manners in the light of all the facts and circumstances, the totality of the circumstances, if you will. That's part of you gotta take into consideration.
Correct.
So I bring that up because, Mr. Dodge asked you on direct exam something about, well, if somebody runs, officer's just gonna chase them. And you kind of said yes. Under wouldn't it be the circumstances? So, for example, since I'll throw this up there, somebody's a stolen car, driver's still in the car, passenger's shooting shots out the window, car comes to a stop, driver runs, passenger stays. What would the officer do in those circumstances?
At that point, like I said I believe in the initial, was that when it's safe to do so. So obviously, the more serious threat at that time is the person shooting, so you'd
Sure.
stay there.
So he's gonna stay there. It's not like somebody runs and you're, kind of a greyhound just chasing whatever runs. You're gonna base it on the facts and circumstances.
No, it's not like a bird dog,
Yep. So it's based on totality of circumstances. So you're gonna take, and then part of that is a crime, obviously, since if somebody's shooting, that's more serious than somebody stealing a car, correct?
Correct.
Going to your use of force, I'm looking at 9-1.3, use of force, and you have kind of a level of resistance. You have potential inactive resistance, passive resistance, active aggression. You're familiar with that?
Oh, yeah.
So active aggression is listed as physical actions or assaults against officers or citizens with less than deadly force, i.e. advancing, challenging, punching, kicking, grabbing, wrestling. That's what that means?
Yeah, that would be active aggression.
Okay. So active aggression, that's what Mr. Patrick was doing, active aggression in this situation.
Correct.
Going to authorize, you have a specific section, authorized use of deadly force, and it does say to prevent the escape of a subject who is fleeing from an inherently violent felony crime. I want to ask you about that. What is an inherently violent felony crime?
It's where you have probable cause that if they're not arrested, that they will harm someone else.
Okay. Do your officers get a list? I mean, do you say, okay, here's a list of violently crime? Because I couldn't find anything, so do you tell me?
No, there's not a list. It's discussed through training. A great example would be that we speak of is the Roderick Danzler incident. He's an inherently violent fleeing felon that needed to be captured.
Okay, so that was the man who killed his, I think it was girlfriend, his family, and then was, driving essentially through the streets, running around like a madman.
Correct.
Well, I guess you list a number of felonies. Is resisting opposing officer an inherently violent crime?
No.
Okay. Is, I guess, simply disarming a police officer, is that an inherently violent crime?
It could be, yes.
It could be,
Yeah.
depending on the facts and circumstances.
Correct.
So, once again, there is no bright line rule of inherently violent crime. It's going to depend on what's going on in that crime at the time.
Correct, and that's what it's reasonably perceived by the officer, and it's reasonable at that time.
Now, part of your training as well, in terms of a taser instructor, you talk about, what you're trained on taser. One of the things on a taser is that it may not work, right?
Correct.
They're kind of finicky, if you will. If those two probes, if a probe misses, you don't have a circuit, you're not going to get the NMI, correct?
That is correct. They're imperfect, but they work.
But they're a tool, if you will.
Correct.
So one of the things you train on is if it doesn't work, you need to be ready to transition to something else, correct?
Correct.
One of the things, and the taser is not the only tool in your belt. Your belt has, you said, an ASP.
Correct.
Your belt has a pepper spray.
Correct.
And even through your use of your training, in desperate situations, a flashlight.
Yes.
You've got a big flashlight, the flashlight can be used to, strike somebody.
Yeah, or your radio.
Okay, or your radio too. So there are other options after the taser. It doesn't go, physical taser gun. There are other options that an officer could potentially use.
Like you said, there's no clear lines of what you have to do following this.
Doesn't, yeah, you don't have a lit, okay, go pepper
It's all-
spray first, and then ask, and then, yeah,
Right.
okay. But it's based on the facts and circumstances, once again.
Again.
I guess I gotta ask this question, and maybe, I guess listening to your testimony, basically, you said he did everything right in this situation.
Is that a question?
Yeah. Sorry, correct me if I'm wrong, I mean, but you said he did everything as he was trained to do, he did everything correctly.
Yeah, he went through his use of force options to the best of his ability during that time.
Then why was he fired?
I did not do that, so I don't
That's
know.
not, but I guess by your training standards, there's nothing based on what he was trained on that should have led to his termination.
I did not complete that investigation, but it's my understanding that there was no training policy or procedure violations regarding the use of force that led to his termination.
All right, thank you, I have nothing further.
Could it be possible Officer Scher was fired because he was charged with this offense?
That is my understanding, yes.
Not because he did anything wrong, because he was charged with this offense. Is that fair to say?
Yeah, that's my understanding.
If you know. As far as Officer Scher doing everything right, does the officer have to do everything perfectly? Is that the standard?
No, the law allows for mistakes. They allow for not being perfect. Was it reasonable at the time it was done?
Now, the taser, the prosecutor brought up the taser, and the taser might not work. So maybe moving to other modes of weapons. Does a officer have to meet intermediate force with another means of intermediate force, such as a baton, or can they escalate that to something higher?
They can escalate if they believe that it is not working or they believe it's going to not be sufficient to control the force.
And if a suspect has a taser in their hand, does the officer need to wait for the subject to use that or to see if the taser works before they advance to something else?
No.
Chasing and arresting. It's often unsafe for an officer to go chase an individual. That was,
There are a lot of job functions that we do that are unsafe.
and the officer's not prohibited from chasing individuals. Is that
No,
fair
they're
to
not.
say? One moment, please, Your Honor. No further questions, thank you.
No further, Your Honor.
All right, thank you, maybe excuse.
Thank you.
Well, Your Honor, we take a very short break. After we're witness tomorrow. Thank you.
We'll take 10 minutes.
I don't know why they keep taking breaks. They shouldn't be taking any breaks. There should be no breaks permitted. No breaks. You guys hear the news? Nancy Pelosi's husband was viciously attacked in his home early this morning. Viciously attacked in his home early this morning. You know what? I'm missing the missing me. Where is it? Oh yeah, there shit is. I'm gonna put it right in the middle right there. Anyway. Yeah, actually, you know what? Maybe I'll put it up in the corner. Like right there. Anyway. Yeah, Nancy Pelosi's husband was brutally beaten inside his home this morning by a assailant who broke into said home. He's gonna be fine. Nancy Pelosi was not in the residence, and the suspect has been captured. That's pretty much all the information that we know about it. Now, I'm sure a lot of people are going to say it has to do with violent MAGA extremists, but it could just be a pissed off investor. It could be like the victim of his car accident, a couple of months ago where he was a DWI and smashed into a car. It could be, someone that just doesn't like Nancy Pelosi because she likes ice cream. It could be someone that's lactose intolerant because Nancy Pelosi really, really likes ice cream. Who knows what it actually is? But we're all very, 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 very happy that Nancy Pelosi's husband was not tragically, or was not hurt anymore, right? I don't know. It could have been anything. Nobody really knows what it was. But who knows? I'm thinking of a new intro for this. So the way this is gonna work is, oh shit, my caption's wrong on the top. Oh shit, oh man, why you gotta be messing with my captions, home skillet? Alright, let me switch back over here. Over here. Yeah, I fucking can sing like a motherfucker. And then I'll put this up there, and then go over to this one. Scooby-Doo, Scooby-Doo. No, I need that there. Fuck, where is it? This? No, that's that one. Oh, you suck. There we go. Now I just gotta move everything all around so it all fits back up in here. You know what I'm saying? Unbelievable. Unbelievable. Bow. Down, down, bow. I don't know why the other thing isn't showing there either. Everything's better with a tune in your heart. Everything's better when you... never mind. I don't have the energy. So this happened in Waukesha. No. This shooting, it says it right up on the top of the page. Don't you know how to read? Literally says Grand Rapids right there, up at the top. Learn to fucking read. You know what I'm saying? Someone probably beat him up for flirting with a husband? What? What are you talking about? Someone else said, I bet it was a beaver. Which doesn't really make any sense. I don't really get that one. Bet it was a beaver. What? What? Someone said, no, read my post. Well, why are you talking about something that I'm not talking about? Susan, or Susie. I'll call you Susan, because I'm mad. Someone said, one other thing is the mayor of Milwaukee's Cavalier Johnson's nephew, 15-year-old, charges of the horrific crime he did 88-year-old woman, but I can't post what he did or I'll get banned again, but Judge Duro will be the judge in that case. Gotcha. You're talking about something random outside of what we were talking about, which is probably why I have no idea what you're talking about. Scooby-Dooby-Doo. Also, the left and the right, the rhino radishes and the lefty lettuce, they're all going ape shit crazy for Elon Musk taking over Facebook or Twitter. They're literally going nuts. All the people on the right are like, oh, can we say all this stuff now? All the people on the left are like, oh, they're going to say all this stuff now. It's really annoying. I hate hearing it. He's a business guy. He bought Twitter because he's going to end up making a shit ton of money in the long run. You mark my words, he will. Someone said there's already an angry radish. Well, good thing I'm not an angry radish, fucker. What happened with this case? Who got killed? I'll talk about it again if you want. So, Christopher Schur was a police officer with the Grand Rapids Police Department. Sometime back in April of 2021, he attempted to pull over a vehicle that had the improper license plates on the vehicle. When he stopped the vehicle, the driver, identified as Patrick Layola, climbed out of the vehicle. He did not listen to any of the commands that were issued by the officer repeatedly, and then he attempted to walk away from the officer. When Officer Schur attempted to place Patrick Layola in custody, or at least detain him, Patrick Layola, determined to get away, began fighting with the officer and resisting arrest. After squabbling for several minutes, Officer Schur, there was a long confrontation, and, guns were drawn, tasers were deployed, and nothing seemed to get Patrick Layola under control. It wasn't until Patrick Layola started getting the upper hand in the confrontation with Christopher Schur that Officer Schur felt that there was no other option besides to shoot Patrick Layola in the back of the head while he was on his back. Or while Officer Schur was on Patrick Layola's back. And, yeah. So obviously, if you watch the video, you're going to be like, wow, this is tragic, but there's no way the police officer should be charged with second-degree murder, as he has been. It's a hard video to watch, but it's about 22 minutes. You know what I mean? But that's it. That's the whole update. This is not a trial. What you're watching now is called an evidentiary hearing. This is where they are attempting to determine probable cause. So I believe the judge actually can make a ruling on whether or not the charges stand. We heard from the training officer of the Grand Rapids Police Department that, in his opinion, former Officer Schur acted within the standard operating procedures. When the prosecution asked, was he fired for violating procedures, the training officer for the Grand Rapids Police Department said no, he was fired because the DA charged him with second-degree murder. That's why he was fired from his job at the police force. He was not fired for any sort of infraction when it comes to being a police officer. He was simply fired because the prosecutor's a commie. There's no ifs, ands, or buts about it. You know what I mean? So that's it. Apparently, and we've learned some new things in this trial, or in this hearing so far. Patrick Layola had a bunch of fake identities in his vehicle. He had 2 warrants. He was drunk, and he was driving drunk with a suspended license. There's his family. That's Patrick Layola's family. The one man next to him is a translator. He's translating the hearings for, I believe, because you could hear someone translating everything that's said. So I believe he's translating for Patrick Layola's family. Now we have the defense coming back in. That tall, skinny fella, that is right there. That is Christopher Schur. And then his immense legal team. I mean, he's got 4 attorneys plus their and the prosecution has 3 plus some kid that's there. But this is pretty crazy. Because this officer should have never been charged in the first place. Becky Marquez said there's Crump. Crump was not there. I didn't see Crump. If you're assuming that a black guy that has a bald head is Benjamin Crump, then that's just racist because I didn't see Ben Crump. Maybe he was there, but I don't think he was. Anyway, what I'm going to be doing is there's going to be a couple of different things I'm doing with the show. So this channel is, obviously, it's in the process of switching over to the Angry Turnip, where I'm going to do a lot of little news, clips, rants, movie reviews, all that stuff in this stupid voice. Why? Because I like it and I think it's fucking funny. The Citizen Stringer TV page is going to switch to either just my name or the Rational American Podcast, and that's going to switch over and just be the show. And, yeah. So there's going to be a lot of stuff. I think this voice is hilarious. I listen to it back on replay and I laugh my ass off. So I don't care if people don't like it. I'm going to keep doing it because I think it's fucking hilarious. So if you are watching on Citizen Stringer TV's YouTube page, here's the catch. You got to go over and like the other page or follow the other page. Because starting on Monday, I'm not going to put this voice on all the different channels because some people do hate it. So when I go live stream during the day randomly or I upload stupid videos, because like Mondays are going to be movie nights. So I'm going to watch stupid corny ass movies over the weekend. And then I'm going to do movie reviews with spoilers on Monday night. Why? Because I like movies. And then, I don't know, we'll call it Turn Up Tuesdays. So we'll just talk about whatever we want. Wacky Wednesdays. I don't know what that'll be. And then, turn up Thursdays? Turn it up Thursdays? Maybe those will be the movie reactions. Or no. Music reactions. That'll be funny. And then Fridays will be Fuck You Fridays. So we'll do call-in shows. So Monday through Friday, I will do live streams every day, plus a bunch of uploaded videos over the course of the week on the main Angry Turnip channel. Do you know what I mean? So, and if you don't like it, you can go suck a big hairy dog biscuit. You know what I'm saying? And then I'll do a Rational American podcast that'll be pre-recorded probably 2 days a week on the Citizen Stringer TV channel, which I'm going to switch the name and everything of today. So that way, people that want to not listen to The Voice can go over to that channel. And then I'm probably going to do another channel about gym shit. You know what I mean? Just diversify. For Fuck You Fridays. That'll be a call-in show called Fuck You Fridays. That'll be funny. Thank you, Thursday. No, that's stupid. I'm not nice. I'm an angry fucking turnip. I'm not nice. Is the new page up? I love Angry Turnip. Yes, it is. And it's only on YouTube. So starting on Monday, you have to, even if you normally watch on Facebook, that Steve Oatley page on Facebook is not going to show the Angry Turnip shit. Maybe I'll link it, but you have to follow that YouTube page. So just right now, fuck it. Fuck it. I'll put the link in there so you guys can follow that page. So I'm going to diversify and try to drive people to the different channels every single time. You know what I'm saying? I got to diversify. Diversify. Yeah. Okay, so they're coming back now. We're about to hear some shit. So everyone on Facebook or Twitch or whatever. Twitch, and then I'm going to do like lunch break video games on Twitch with this voice. Because I play video games. And I know a lot of people don't like it. So I don't want to fucking upset, get your panties all in a bunch or nothing like that. But I do what I want because I'm the boss. Yeah, I do what I want because I'm the boss. I do what I want because I'm the boss. Do what I want. All right, ready? Yeah. Turn it up Tuesday. Yeah. Fuck you Fridays. Yeah, I don't feel like doing the songs. But yeah. So I just put it in on the chat. On all the chats. That YouTube, that's the YouTube page that is the official The Angry Turnip page now. So that's where, slowly but surely, every single thing will be in this voice on that page. And if you want to hear regular shit, go to the other pages. Which I'll link them all. Right now they're not all linked, but... You know what I'm saying? The Crumbley court is on. I don't know what you're talking about. I watch it every day just to see the crappy poll, just like when Steve streamed the riots. Yeah. Steve's Chucky voice really scares me. This doesn't sound like Chucky. This shit don't sound like no motherfucking Chucky up in this bitch. What the fuck you talking about? Oh, God. My stomach fucking hurts this morning. Stomach fucking hurts this morning. Pag1001 on Twitch just bought a 12-month subscription. Dude, you fucking rock. You're my favorite. I don't even know what that means. Someone told me, though. Someone said just knowing how big he really is and hearing this voice is a shiznit. Yeah, it is. Anyway, this is back on.
All right, and the people have a motion.
I do, Your Honor. I would move for bind over on the count of second-degree murder. Your Honor, for a brief argument, I know the court has already gotten our brief and gotten to the defense brief, but I want to touch on a few things. And to be frank, I guess we've had discussions a little bit, but I don't think this is a close call for the court. I think it's fairly easy for you. Basically, the court is very well familiar that the elements of second-degree murder are a death caused by the defendant. In the circumstances of this case, it's very clear there's an intent to kill. That's not an issue. The only issue in this case is the element number 4. Is there some sort of justification? And that's what the court to some extent has got to determine, but ultimately, that's a jury question, Your Honor. I think the law is behind this. And they offer, essentially 2 reasons of justification in their brief. First, deadly force to prevent a fleeing felon. Your Honor, the fleeing felon defense, it is there, but what is the key thing? The key thing, and we agree, that's the thing, a lot of things we agree on in terms of People versus Couch. They cite in their brief, when you look at People versus Couch, when you look at them, I'll quote directly from that from that case. Both officers, this isn't just civilians, officers and private persons seeking to prevent a felon's escape must exercise reasonable care.
All right, here, real quick. So what a bind over, that's referring to the judge's decision to order a defendant, i.e. this former officer, to be subjected to a trial. So this whole thing is on this judge right now.
And that goes true for their
They
other
should drop
reasons,
this shit and
is
let the guy get back on with his
self-defense,
life.
Reasonable self-defense. Well, once again, we've said People versus Heflin, and the general test, and the court's well familiar with it, though, is that the defendant honestly and reasonably believes he is in danger. The danger the defendant fears is serious bodily injury or death, and the defendant's use of force appears immediately necessary to defend himself. So once again, necessary, immediately necessary. You can pull up that. We've presented well beyond the probable cause standard to show that this is somehow immediately necessary. And I was going to pull up, you have your, I don't know if that pulls up again.
Through Zoom, or you on through Zoom here?
I'm using one of the defense exhibits. This is the defense exhibit. And in terms of when you're talking about necessary and immediately necessary, this is the exhibit. The last thing where we talk about, you can see the casing discharging from the gun. This is the moment the shot is fired, okay? As a matter of law, can the court say this is necessary to prevent a felon's escape? That this is immediately, there's self-defense that's immediately necessary when Patrick's lying face down on the ground with the taser's not even pointed at him? And then you add on with what the medical examiner said. This is a direct shot to the back of the head. This is a contact wound. There's no suit around the wound. That's in the transcript you have. It's a contact wound to the back of the head with the bullet traveling back to front and upward. Upward in terms of in the head because he's down on the ground. His face is down on the ground. So as a matter of law, the court can say this is immediately necessary. That's not your call. The cases all say that this is something for a jury to decide. The Hampton case that we cite, this is something for a jury to decide. Self-defense is something for a jury to decide. I hate to say that, Judge, this is, it's something for you to do. It's not a question of, well, they've called an expert. They called an expert. Chad McKersey had an opinion that, yes, this is all reasonable. As you all know, jury instruction 5.10. You can disregard an expert's testimony. We had a lay witness saying, well, this is an execution. That's why this is a jury question. People differ. And it's going to be up to 12 people from Kent County to make this decision as to whether this is reasonable or whether this is necessary. And I think that's the ultimate question, and it needs to be bound over based on that reason, Your Honor. Thank you.
Thank you, Mr. Beck.
Thank you, Your Honor. Your Honor, we agree with the prosecution that it is his burden to show probable cause for the court to consider on each of the elements of the crime. We also agree as to the elements of second-degree murder. A death caused by an act of the defendant, absent circumstances of justification or excuse, and done with the intent to kill. There's really no dispute here as to the cause of death. We didn't hear from the medical examiner here, but the transcript shows that the cause of death was a gunshot to the head, which went from the back of the head out to the right as the defendant turned his head to the left. So as the defendant was turning, a shot was fired, and that's in the medical examiner report as well. But there's really no dispute as to the cause of death. It was the gunshot. He didn't die from any other cause. There is a significant dispute as to the law of what the prosecution must present to the court and what the prosecution must show by probable cause to the court for the court to bind this over. So there really is this initial question, which the prosecution has briefed and also has talked about today, is whether or not this is even a crime. And we don't think this is simple, and we don't think this is not a close call when it comes to the law. The prosecution's standard is apparently that this court might find probable cause that this was not immediately necessary. I believe.
Well, I don't want to interrupt you, but I'm interrupting you. I want to ask you some questions, see if I can have you focus the argument for the benefit of the court.
Of course, Your Honor, and I'm happy to.
Let's presume, because I think you're right. I think that there is some murkiness in the law as far as what the actual standard is, and it appears to me that the standard in Michigan is still the old common law standard. But let's assume that it is the worst standard for your client. Then apply the facts to that.
When you say worst, meaning the most difficult
To overcome.
to overcome or defend.
To suggest that, and I think it would be the common law, obviously, the notion that it is highly privileged, the right to defend or stop a fleeing felon.
I mean, is the court suggesting that the common law is a more restrictive standard on the officer than Tennessee v. Garner?
No, I think.
Just the opposite?
It's the opposite,
Okay,
yeah.
so we agree on that. And so the court wants to know whether under Tennessee v. Garner,
Yeah, correct.
I think that the undisputed evidence that the court has heard is that the officer acted reasonably under the totality of the circumstances. So if this were a civil case, which it is not, the only evidence the court has heard is the opinion evidence of Captain Kersey. And now there's a video of the killing, but that proves the killing, and it proves that it was Officer Scher was the one that shot Patrick Leola. The question of justification under Tennessee v. Garner, the civil standard, that is
Let's
that.
do it under the common law then.
All right. Well, the common law, I think, is even less restrictive. I think the state of Michigan has one of the least restrictive laws anywhere in the country. After Tennessee v. Garner, most states, in fact, almost every state but two, decided, we should get something on the books to decide when an officer can be charged with a crime and when a private citizen can be charged with a crime. And there's a difference.
Let me ask you this. Here's really where I'm getting at. Even under the common law standard, isn't there still the question of necessity that applies in laws over the entire thing? It's not an absolute, because you're asking, in order for the court to not bind you over, the court has to conclude that under no circumstances, no reasonable person could conclude that this was beyond what was necessary. Isn't that
And
the standard?
if I could ask the court a question, what does it mean for a police officer to do something that was unnecessary?
But
Well, I'll tell you what the state of Michigan and its common law has said, because there's been a divide, if you look at the cases, before and after Tennessee v. Garner, of what an officer can do and what a private citizen can do. And the cases do not speak of necessity as to an officer. All those cases that Mr. Becker's talking about, that has to deal with a private citizen and when he can act in a citizen's arrest. In this state, Your Honor, if you go back 150 years, I mean, people will be appalled about what a private citizen could do. And, I mean, there's a great discussion in the Whitty case, which is in both of our briefs, where, and I would just like to read a passage talking about the evolution of common law, which this court must follow in the state of Michigan. And this is because prior to this, and Tennessee v. Garner talks about this, most felonies, you were imposed a death sentence. And shooting a nonviolent fleeing felony historically would have been permitted because it's the same result as if he'd been caught and convicted. And on Tennessee v. Garner, this is no longer the situation, and for good reason. No one's suggesting that that should be the law, but it, whether it is, should be, or should not be, is not the question for this court.
But wasn't exactly what you're suggesting rejected by the Supreme Court of People v. County? I'm looking at footnote 1, where the majority said, hey, to view Garner as creating a separate standard under Michigan's law would essentially create two different definitions of murder, manslaughter, one for police officers, one for the rest of us. Such a scheme could raise a significant constitutional question. Isn't that what you're suggesting?
I think the constitutional question that they're suggesting there in dicta is that what is the due process to the officer or a private citizen if they don't know what necessary means in the circumstance? So there certainly is a due process argument, and I agree with the Supreme Court there, because this has not been resolved. Certainly on that level. That case involved a private citizen. And in the Whitty case, it says the common law in Michigan recognizes that the occasion may arise where a private citizen is confronted with the choice of attempting a citizen's arrest or letting the felon escape in order to make a citizen's arrest. It is regrettable, but sometimes necessary to use deadly force. The common law in Michigan recognizes, but still stops far short of granting a private citizen a license to hunt down and kill those suspected of committing a felony. The use of deadly force is not justified if the person is to be arrested is not, in fact, a felon. Additionally, and most importantly, the use of deadly force must be necessary. And we're talking about a private citizen, either to meet deadly force or to prevent a felon's escape.
Then what would you suggest is the standard that would apply to police officers? One that is completely unreviewable?
No, of course not. There is a standard. Police officer in People v. Fiedler, because it was an officer in that case, was charged with involuntary murder. And this is when they said he could use deadly force. The officer used deadly force when necessary to prevent the person from being arrested for fleeing. So if he's going to get away, you can use deadly force. That's
Kind of a predicate felon.
yes, and I don't think that's in dispute here. Even the prosecutor admits and concedes that there's ample felonies.
Can the felony be
A question of fact?
resisting arrest? I mean, that's the.
Absolutely.
And why-
Well, and I didn't get to the second prong, Your Honor, because the
Well,
second prong
no,
says
but,
there's no necessary requirement in Fiedler when the arresting person is met with force from the party to be arrested. And this makes perfect sense if you look at our history of common law. Because up until now, and there is no statute, if you go back 100 years and you said somebody, if you fight with a cop when he lawfully is arresting you, not talking about an unlawful arrest, he's constitutionally got the right to arrest you, and you fight with him, resist, active resistance, like Detective McCursey said, then you have a right to use deadly force.
would that be a felony at common law? That way it wouldn't.
Resisting and obstructing?
Correct. At common law. I mean, that's, but if it's a common law.
Absolutely it's a felony.
If it's a common law standard, and the common law standard is by way of reference to felony, wouldn't that be, not felony as we understand it today, but a common law felony? And those are, and there's 9 common law felonies. They're very specific.
So it comes down to whether or not he committed a common law felony.
I don't know, isn't it?
I would think disarming a police officer is a common law felony. Assaulting a law enforcement officer is not a common law felony?
There's 9 common law felonies.
Okay.
Murder, robbery, manslaughter, rape, sodomy, larceny, arson, mayhem, and burglary.
Mayhem.
All right.
If that isn't mayhem, Your Honor. I mean, there's a reason we have we have statutes, so people understand how to conform their behavior. And perhaps shame on the legislature for not addressing this issue. But we cannot held the officer to a higher standard.
The common law crime of mayhem is defined by an act of maliciously disabling or disfiguring the victim.
And so when the arresting person is met with force from the party to be arrested, People v. Fiedler understands that to mean a police officer can use deadly force. And it was an officer who was shooting at someone who was running away.
Yep, and as far as mens rea is concerned, it is not actually in modern law to have the intent to disable or disfigure, as long as the defendant intended to injure the victim, and disablement or disfigurement was a result of a defendant's act. They're going to drop the charges. They're going to drop the charges. I guarantee it.
Charged in Michigan with murder.
I hope so.
And here, if you look at whether or not he's fleeing, I mean, I think the question of necessity. You have Patrick Lilla, it's a lawful stop. You had heard no evidence that this was an unlawful stop. I don't think anybody who's got any experience in criminal law would suggest that there wasn't grounds to pull him over. The methods he used through this system were perfectly in line with his training. Well, maybe not perfectly, because that wasn't the standard, but they were in line with his training. The training officer told you that. Patrick Lilla jumps out of the car. He fails to obey any commands. 30 commands. He uses active resistance, shoves the officer, and he's committed a felony at that point. And he flees. He has reason to flee. So we know he's fleeing because, as Detective Stasiak said that she found in the car, it's loaded with evidence of identity theft. And he also has active warrants out for him.
Yeah, he did.
So this is a lawful arrest.
He was a bad mamma jamma.
Before and after they searched the car, which is what it would have done. And Patrick Lilla knew this. That's perhaps, we don't know what was in his head, but that's the most likely reason he was fleeing. From the officer's point of view, he has no idea who he is at this point. It is 8 a.m. Monday morning. He knows this person is not listening to anything he says. He is calm, he is respectful, and as Patrick Lilla escalates, the officer responds, but in kind. He doesn't, this is not the old West where it's a fleeing felon and he's like, well, I'm going to shoot him because he's 4 feet in front of me. He doesn't do that. And he had the absolute right to chase him, especially, think of the situation. It's a school day. It is 8 a.m. What would we be calling Officer Schur if he had let Patrick Lilla go? From his perspective, he has no idea who this person is other than he jumped out of the car and wouldn't listen to the thing he said, actively resisted, and ran. And he's supposed to just let him go? He's at .33. If he had got back into another car or went into a building, which are all reasonable things to consider if you're an officer.
.33? No shit.
If Patrick Lilla had run somebody over, or gone to a school, which were nearby, we'd be calling him something else. At a minimum, we'd be calling him a coward. And so we're calling him a murderer here because he didn't let him go. That's the suggestion. Because it wasn't necessary. It wasn't immediately necessary.
And those, I understand all those arguments, but aren't those arguments better put to the jury? That's really what it comes down to. Is we're here. The question is simply whether there's a probable cause. Those are all arguments against it. All arguments supporting that everything was reasonable. I mean, at the end of the day, that's the standard.
Well, a lot of issues are left for a jury when there's a conflict in what the facts could be. If the issue of justification, even under the most restrictive standard, Tennessee v. Garner, is the jury going to rely solely on their understanding of excessive force laws and training of police officers in this case? No. They're going to rely on expert testimony. The prosecution decided they don't want to call their expert. So there is no evidence, no opinion evidence of what is excessive, what is reasonable, what a reasonable officer would do, except Officer Scher's training officer, who has decades of experience, who knows exactly how to train these officers, and he said he exactly followed his training. And under the totality of circumstances, this was reasonable. So what facts do you have, Your Honor, that this, under the totality of the circumstances?
The court can draw reasonable inferences, it's required to draw reasonable inferences. And, you know, so you're asking me to conclude that no reasonable fact finder would find that this is anything other than reasonable.
Yes.
That in turn really is, you know, that question is one that to say that reasonable minds cannot differ on that.
Well, you've only heard from one mind, Your Honor.
No, we've heard the facts, and again, you know, one of the things that stuck out to me was, Captain said, well, you know, we don't really know whether Patrick Leola was, in his aggression, was trying to break the grasp in a defensive way or attack the officer. And I don't know if that would change things or not.
I don't think that matters under the law. I don't see that it makes any difference under the law. And I'm only asking the court to make legal determinations, except to the fact there are undisputed facts. Certainly, the court's going to assume certain facts, and not everything goes to the jury. I mean, the court will make a finding that Officer Scher is a GRPD officer. There are lots of things the court finds because they're not in dispute. If the prosecution truly believed that this was unreasonable, they should have put on some evidence that it was unjustified, not just play the video. That's not the standard for this court. You are the gatekeeper of whether or not something should go forward. Because the prosecutor even said, well, if this was reasonable, why did he get fired? And the only reason he got fired is because he was charged. So no one's made a finding that this was unreasonable other than the prosecutor. And so now we're asking you, given what you've heard, the opinion testimony of the training officer, that's unrefuted, no rebuttal, how can you make a finding that a reasonable jury could find that this wasn't justified as the standard is set by Tennessee v. Garner? And, Your Honor, I do want the court to consider the common law with regard to the second prong, which has not even been addressed by the government, which is that it's justified that what Officer Scher did if he is met with force in response to a lawful arrest. This was a lawful arrest. There is absolutely no evidence whatsoever that he did anything unlawful in effectuating an arrest. And there's absolutely no evidence that Patrick Leola did anything but fight the entire time. He pushed, he shoved, he popped his arms. He's committing an inherently dangerous felony, according to Captain McCursey. And, you know, that's all policy, which, by the way, is not relevant for common law. But if it's going to guide or inform the court on what is actually reasonable under the circumstances, Captain McCursey said it's inherently dangerous. I would say that the court just looking at the video, that's an inherently dangerous situation. You have a person who will not comply, who grabs a taser, who ultimately takes the taser from his left hand to his right. So at some point, it got transferred and is turning, as the medical examiner's report states. because the bullet went from the back of the head out the right. And he concedes, yes, his head was turning. And if you look at the video closely, you can see the taser going this way. And so the officer, in this case, is not held to a standard of what was it really necessary to shoot him. That is not the standard. The most restrictive one would be Tennessee v. Garner. Or would any reasonable officer, any, in this situation, have acted that way? We can't find an officer who would say that they wouldn't have acted with deadly force in that situation. He disarmed him of his taser. Their own expert is talking about how dangerous these things are, even in drive stun. You can lose an eye, it can collapse a trachea, it can kill you if you hit it in the right spot. So whether or not the second cartridge was fired is completely irrelevant. Nobody has said that that's sort of the question of fact for a jury to decide. Well, if it was only the drive stun, then it's not, can't cause bodily harm. So no, that's not. Their expert on tasers says this is, we train people, do not drive stun somebody in the face, in the head. Stay away from there. Why is that? Well, it's huge liability, not only for the officers, but probably for Axon. So this is not a civil case, but even if it were, you have heard no evidence whatsoever that the experts in the field think that this wasn't unjustified. So it certainly is an issue of active resistance, and under common law, when met with force, making a lawful arrest, you can use deadly force. Now, should that be the law? No, but that's a question for the legislature, not this court. Whether or not it was necessary to use deadly force when met with force, I don't think is the law. And respectfully, I encourage the court to read the cases that talk about that second standard. Almost all the cases talk about the situation where someone is running and he's getting away, and do we really want a private citizen to wing somebody from 20 feet because they think he's going to get away because he committed a felony? That's what these cases are talking about. The reason there's no cases about all the times we've charged police officers with murder under common law is because it's not murder. He has the absolute right. In fact, he has the duty to arrest him at this point. It is his obligation. And the difference, Your Honor, too, between private citizens and police officers is that private citizens now have a duty to retreat. We don't want average guys running around making citizens arrest and feeling they can essentially stand their ground if they're met with force. If you're in Michigan, I know some states have stand your ground laws. We're not one of them. In Michigan, if you're making a citizen's arrest because you know someone's committed a felony, if you have the opportunity to retreat, you absolutely have to. Otherwise, you're not going to have a defense of self-defense. You have to retreat. If you can call a police officer, if it's reasonable in the circumstances, you must do so. Only when it is absolutely necessary, and this is where the necessary comes in, can you arrest that person. That doesn't apply to Officer Schur. His job is to arrest people. That is absolutely his job.
But then you're asking this court to recognize something that the Supreme Court said doesn't exist, shouldn't exist. You know, it's two separate crimes, two separate standards. One standard for private citizen of what murder. One definition actually is what it is. Of course, private citizen versus a police officer.
Well, if the court believes that private citizens and police officers are in the same shoes when arresting people, then I guess we're going to have to disagree on the law. But I don't think that's what Couch said.
No, but it's all part of what are the circumstances. I mean, at the end of the day, when you have a police officer, the circumstances are different. You know, ultimately what I'm getting at, though, isn't that ultimately the question of fact that the fact finder has.
I think first we have to figure out what the law is.
Okay, let me ask it this way.
Yeah.
Regardless of what the law is, though, isn't it ultimately, there's always going to be a question of reasonable necessity, no matter what the law is. Granted, that it may apply differently, but it's that fact finder that's doing the application, not the court. Because if the court makes a decision, then it has to say it's an absolute privilege. And I don't think the law says it's an absolute privilege. There's some limitation.
Yes, and
Some limitation.
there's a limitation on when they can arrest. For a private citizen, you have to actually, either it has to happen in your presence, or it has to actually be the person that did it to do a citizen's arrest. For Officer Scher, the question is whether a reasonable officer in that situation would believe he had probable cause to arrest. And you have to have probable cause to believe that's the person that committed the crime. So is that a question of fact? No, I think that's a question of law for the court, as the law routinely makes that determination. Now, if the law is that there's this third element that is discussed nowhere in Michigan common law, that it has to be necessary, nobody knows what that means. I will tell you this, Your Honor, nowhere in their training, nowhere in MCOLs, nowhere does it say that the standard is that it has to be necessary. And so it's necessary to do what? Was it necessary to effectuate the arrest? Was it necessary to protect himself? What does necessary mean? I think that the reason there's no definition for the court to look at is because it's not required. So there are two prongs. Was there probable cause to believe he had committed a felony? And was, in response to the arrest, was the suspect providing force in response? And this is perfectly consistent with common law. If you go back, that case that was cited was 1980, by the way. It seems like it was from the 30s. That's 1980, the Whitty case. They're lamenting that private citizens don't have the same rights as police officers anymore to, in their words, I mean, I was just frankly stunned. The common law in Michigan recognizes that private citizens and police officers don't have the same rights, but it falls short of granting a private citizen a license to hunt down and kill those suspected of committing a felony. I know it's shocking at least. And the legislature has had decades to lay down some protection for citizens and for officers. But we're still with the common law. And I don't think the common law says a jury is going to review whether or not it's necessary any time an officer used deadly force. Otherwise, you could just charge a crime every time an officer pulls his gun. If it's ultimately just a question of fact for a jury, what's to stop the prosecution from charging anyone any time they hurt somebody when they're resisting arrest? Oh, that's an assault with intent to do great bodily harm. The necessity is not an element of the two-pronged fleeing felon rule in the state of Michigan. And that's our position, Your Honor. I mean, it's a difficult one. There's not a lot of guidance for this court. And I'm not saying that should be the law. We're saying, I'm getting lots of notes. And so ultimately, it is the prosecution's burden to show probable cause, and whatever the standard is. And I think the court has to set the standard first before deciding whether or not probable cause has been met. Because there are circumstances where you make findings of fact, and here they're completely undisputed. That you heard no evidence that it wasn't reasonable, even under the most restrictive standard. For that reason, we ask that the court deny the bind-over order and discharge the defendant.
Thank you, Mr. Becker.
I guess the biggest thing, now that we're representing in the Fielder case, and in terms of saying their idea that basically that if somebody uses force to resist arrest, all bets are off. The Fielder case was remanded because the Fielder decision was it's up for the trier of fact. I mean, so the own case that they cite says this is a trier of fact issue. So we can talk common law and everything else. All the cases say this is essentially something that is to be sent by a jury, and it's not for a judge at this stage to decide. And I don't know how you get around Couch. I mean, Couch is the one they cited, and they left out that section. But Couch, in that section that I read about, it applies to officers and civilians, was citing a case from 1930. So to say that, this is somehow new and we have no idea, they're basing case law since the 1930, and common law is based on case law. So I don't know how you can get around saying, well, there's no necessity in the common law when we have a case that's been out there since 1930 saying exactly that. This is a jury question. All these arguments, they make well-intentioned arguments, but it's for a jury, it's not for this court. There's a sufficient basis to bind this over, and we ask the court to do so.
All right, thank you both for, thank you all for your courtesy to one another throughout the proceedings.
Is he gonna rule right now?
And professional.
Come on, buddy.
I am going to take the matter under advisement. I'm going to review all the evidence, I'm going to review the applicable law, and I am going to give you a decision on bind over on Monday. And I intend to draft a written opinion, and then we'll present it in court, at 10 a.m. on Monday morning.
10 a.m. Monday. Be there or be squared. I am going to switch to a different court hearing the second this is completed.
I don't believe so, Your Honor.
All right. Again, thank you everyone for your courtesy. And we'll see everybody.
All right, so we're going to switch over to a different court hearing. Now we're going to go to the family of Ethan Crumbley. I think it was Ethan Crumbley, the school shooter, also from Michigan. The parents have been charged with manslaughter because the state actually used rational thought. And there's a hearing going on regarding expert witness testimony in their manslaughter charges. So we're going to switch over to that hearing, and we're going to see what's transpiring over there. Yeah.
About how to stop school shootings, correct?
I have done trainings just for parents.
Okay.
I'll switch the overlay in a minute.
Is on schools and school employees, is that fair to say?
No,
Okay, what is the bulk of your work then?
the bulk of the training that I do, different practitioner groups, law enforcement, reporters. I do a lot of work with schools, but I wouldn't say it's the bulk, no.
Okay, so law enforcement, reporters, some of the parents can be a part of it. You're trying to target the classes of people that would have the contact with children to be able to make a difference. Is that fair to say?
Yes, anyone who has regular contact with young people.
Okay. And you did a study, a more recent study about experts being able to assess shooting threats. Is that correct?
Yes, it's currently under review.
Okay. So you did research to determine, one of the questions you're asking and trying to determine is, why aren't experts better at assessing school shooting threats, correct?
Yes, why are they inconsistent?
Okay, and one of the things that you found, so when you're dealing with this study, I'll say it as I understand it, but please stop me if I'm wrong. You surveyed 229 senior law enforcement officials and officers. Is that correct? Mm-hmm. Is that a yes?
Yes.
And those law enforcement officials and officers, they were people who are directly responsible to assess threats that could be in a school shooting. Is that correct?
Yes.
Or in a potential school shooting?
Yes.
And the research asked these senior level officials and officers to use a scale of 1 to 10 and look at materials and determine on a 1 to 10 level if it was to rate the severity of what they were seeing, is that correct?
Yes.
So, for example, you would give them a drawing, you know, a hypothetical drawing that a student did, and then you ask all 229 people, rate this drawing on a scale of 1 to 10, how severe of a threat is this, correct?
Yes.
And one example is you guys had a drawing. It was a stick figure that was portraying a school shooting in a trash can. That was just one example of a material you used to give to these investigators and say, assess the risk, correct?
Correct.
And these trained senior law enforcement officials and officers scored the drawing, and on that one in particular, 62% of the experts rated the threat as low, correct?
Yes.
They scored it between a 1 and a 3 out of 10.
Yes.
And then only 27 of the 229 scored it as an 8 or higher, correct?
Yes.
So even trained senior law enforcement officials, there is not consistency among them when they look at a drawing or a piece of information to determine the risk level, correct?
If they look at that piece of information with no other context and without knowing anything about the student or anything about the situation, then that is correct. Yes.
Okay. And so there's also questions that need to be researched about how to weigh the severity of threats made on social media. That's something else to be considered, correct?
Yes.
And
The lawyer that's speaking looks like the adult gay son on the show Shameless with a wig and dressed as a woman.
that we need to keep studying this and we need to come up with some guidelines, right?
Yes.
And that's a work in progress through today and into the future, correct?
Yes.
There was also another example in the study where there were photographs of classmates and it looked like there was either a gun or a heart emoji posted on Snapchat with the student's face, correct?
Yes.
And on that one, 45% of the experts assessed that to be a low threat between a 1 and a 3, correct?
Yes.
And only 15 of the 229 rated it an 8 or higher.
Yes.
Okay, so again, there is not consistency even among highly trained, experienced officers on the risk level when it comes to looking at a piece of information.
Inconsistency on the risk level, but there was a lot more consistency in how they would respond and investigate.
Okay, and one of the benefits we have after, I guess a benefit, after a school shooting has taken place is the ability to look backwards at what could have been done, what should have been done, what wasn't done, correct?
It's true.
And unfortunately, there's no way to predict these things in advance. And let me be more specific. You don't have a checklist of the criteria of what makes a school shooter, correct?
Correct.
All of the factors you talked about in the database show there's many contributing factors that can be looked at, but there's not a profile of this is going to be somebody who should be on our radar as a school shooter.
There's no profile, but there is a pathway, and leakage being the most critical component of that pathway.
So I'm going to ask you, I'll turn to leakage. When you're talking about leakage, the drawing Ethan drew that's been admitted as I think Exhibit 5, those drawings were identified by you as leakage after the crime took place, correct?
Yes.
Now, if I had drawn those same drawings but did not commit a shooting in a school, it would not be considered leakage.
It would be considered leakage. It's any communication of intent to do harm.
Okay, so any communication of intent to do harm, including times when harm is not done, all counts.
Correct. That type of drawing would be something you would want to investigate and intervene with, regardless of what the intended outcome was going to be. Yes.
In putting together, in looking at the leakage though, part of your definition is that it goes to a third party, correct?
Yes.
We're not talking about documents that are hidden that only the shooter sees,
Right.
correct? And your testimony in this case was that there was a lot of leakage by the shooter.
Yes.
And to third parties.
That third parties were made aware of. Yes.
Okay. Now, when you looked at the materials, and I imagine they were provided from the prosecution,
Yes.
you looked through, I'm just going to go through some of the materials, okay?
Okay.
You looked through some of Ethan Crumbley's notebooks from home, correct?
Yes.
You have no knowledge of who saw the contents of that notebook.
I don't know.
So if we don't know who saw it, we don't know there was a third party, do you still consider it leakage?
Depends on where the notebook was left in the home.
Okay, so the notebooks from home, you have nothing to show that mom or dad saw those notebooks or wrote anything in those notebooks to Ethan about what he wrote, correct?
I no.
There was a journal that Ethan wrote in, it looks like November of 2021. You have no information, and you said that was leakage, correct?
It was leakage because the evidence shows he was writing it in class, in public, in his house, right? It wasn't something he kept hidden.
You have no information, though, showing that that leakage was seen by Jennifer or James Crumbley, correct?
I don't.
There were a number of text messages that you saw between the shooter and a friend of his who's also a minor, so I'm not going to say his name. And certainly in those text messages, there was leakage where the shooter wrote out some of his plans, correct?
Yes.
And you have no evidence to show that James or Jennifer Crumbley ever saw those text messages, correct?
I don't know.
And when the shooter in this case says things to a third party, so for example to his friend, saying, I asked my mom and dad about blah, 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 going to a doctor or whatever, you don't know if that's a true statement that really happened, or if that's just something the shooter is saying to his friend on a text.
I only have the materials I reviewed.
Now, very early on in this case, you heard about the Oxford shooting right away as it happened, I imagine.
Yes.
And you wrote an op-ed piece very early on in the case about some of the distinctions between this case and other school shootings. Is that correct?
I believe so, yes.
And the op-ed piece was actually written like the first week of December, so within about a week after the shooting took place.
Yes.
And at that point, had you been in touch with the prosecution regarding this case?
No.
In the op-ed piece you wrote, one of the items that you seem firm on is that you believe that Ethan was given access to the gun by his parents. Is that a fair statement?
Yes.
And in your report, some of your opinions rely on the fact that you believe Ethan was given access.
Can you follow this?
Oh, I'm sorry.
No, I know it's an inadvertent.
Okay. That the shooter was given access to the gun by his parents.
For the op-ed, I was relying on previously published news accounts of what had happened. So those accounts are linked within the op-ed. And for the report, it references the Instagram posts and things that I relied on. Yes.
Okay. And one of the, you would agree with me that sometimes the news, God bless them, does not accurately report what's happening in a case or accurately report the details of a crime, things like that, correct?
Not 100% of the time, right?
Okay. And that's actually one of the limitations, even in your work in compiling the database, is that you have to rely on information given to you by other people that you can't always independently verify, correct?
We triangulate sources with firsthand and primary sources whenever we can, but yes, there's cases where we do use secondary sources.
And in, for example, one of your published studies about the communication of intent to do harm before a mass shooting.
Wait, what? Gwyneth, are you fucking stupid? Gwyneth on Facebook. What the fuck is this comment? You can't be real. I haven't been watching this. It seems unfortunate that the defense attorney is wearing black and white stripes. Kind of puts jail on their minds. That's the fucking defendant. You fucking, oh, you get this stupid comment trophy of the day. There's 2 defendants in this case. Oh my god. Oh my god.
The gun, that creates, we can agree that would create some bias in your mind about these parents.
I guess I just was relying on the evidence that I was provided in the report.
In the limitations section of your article, you note that there's sometimes misinformation because the source data was originally gathered for purposes different from our own. So the database that you have right now, some of the data in there was derived from databases that were created for other reasons. Is that correct?
Yes, which is standard practice in our field.
And there were situations where you write it's possible there was leakage, but information was not made publicly available for you to be able to look at.
Yes.
And in trying to look at the database and create it and compile it, there's times where you hit some roadblocks like HIPAA getting in the way of getting medical records and things like that, correct?
Yes.
And there's...
It's probably jail policy, the masks. Doesn't she look like the gay dude from Shameless? Doesn't she look like the gay dude from Shameless dressed as a woman with a wig? She looks just like him.
Related to something else, correct?
Yes.
So there's some question about, there's some room for parts of the database that we cannot say are 100% reliable.
That's true of all research in this area, but yes, we used as many sources as we could find.
Ian, yeah. She does, dude. It's fucking creepy. Oops.
In your book, there's an example about a kid who got a pie from someone. Do you know what I'm talking about? Yeah. Okay.
Tell me
So
she doesn't.
There was, my understanding is there
Tell
was
me
someone
she
who did
doesn't.
commit a
She
mass
looks
shooting.
just like him.
Is that correct?
What the fuck?
And they
She looks just
had a
like him.
friend who was making a pie for them.
Wow, dude, that's
and They
trippy.
claimed that because somebody cared about them and was making the pie for them, that stopped them from committing the shooting, correct?
Yes, it gave them hope and got them through their crisis point.
Okay, and part of what you hope to see is administrators, school officials, helping students get through their crisis point as a means to block and stop a mass shooting from happening, a school shooting, correct?
Yes.
Okay. When it comes to the example with the pie, we don't have any independent facts showing that this person had the plans and the gun and the materials and all of the things to truly commit the shooting, correct?
That's a first-hand account, so we just have his first-hand account.
Okay, so his first-hand account could be true, that this idea somebody made him a
What the
pie,
fuck?
stopped him from shooting. Or it could be a feel-good story. Could be true, is that a fair statement?
I mean, in terms of collecting interview data and analyzing it for kind of social science purposes, yes, you would try to triangulate that with independent sources if you could.
And that pie example is one of the ones you use to show that sometimes it's little actions that can help stop a shooting. But that example, we don't really have much information about it to show that a pie is going to stop every shooter, correct?
That is one anecdote in the book. There are others, yes.
At the end of the day, every shooter is different and has a different background and different plans. Is that correct?
Yes.
And there is no recipe for us to put in place to guarantee that we're going to be able to prevent future shootings.
I would say there is a recipe we could put in place.
There's a recipe we could put in place and hopefully minimize it, but we don't have any proof yet that this is definitely going to work. It's going to stop all school shootings.
We do not have that data, no.
Now, one of the things that does make a big difference is when there's kind of an intervention or law enforcement becomes involved in finding out there's plans in the works for a school shooting. Is that a fair? That's a horrible question. Okay, let me back up. Okay, on Monday of this week, there was a school shooting in St. Louis. Are you familiar with that school shooting?
I have read just the news coverage. I haven't studied it.
Okay, in that school shooting, the police had the gun the week before. Are you aware of that?
I read that in an article.
Are you aware that the shooter in that case had been committed, had a mental health commitment prior to the shooting?
That is not a case I've studied, I'm afraid.
Okay. I guess the bottom line of what I'm asking you is even sometimes when there are interventions and things done, a school shooting can still happen.
If we're talking about that case, I haven't studied it.
Okay. The Parkland shooter. You've studied the Parkland shooter.
Yes.
He's part of the book. Okay. We can agree he was on the FBI radar prior to the shooting.
Yes.
And with him being on the FBI radar, he was still able and did commit a violent school shooting.
Correct. There was a lot of missed warning signs in that case.
With the database that you have prepared, you have have already added Ethan Crumbley to the database.
Yes.
And one of the check marks that Ethan Crumbley is checked off on is that he was neglected as a child. Are you aware of that?
I wasn't one of the original coders, so no. But
Okay.
I'd have to look at the data.
So, in terms of what data would support that Ethan Crumbley was neglected as a child?
Judge again.
If you know.
Yeah, I don't want to, I know it's hard to avoid. Please don't mention his name.
Oh God, sorry. Okay.
Thank you. I think it just, I think it's upsetting for the victims.
I apologize to them and to the whole court. I'm not trying.
I know you don't mean it. I know you don't mean it.
That case was coded by 2 independent coders using publicly available information, so I would have to gather the source files. But we know that the best data about each case doesn't become available until sort of 2 or 3 years later, oftentimes, when FBI reports and things are released, so that's when we go back and we make sure we're revising the data.
Okay, so the data is always subject to be revised when you have more information down the road as things continue.
Yes.
And it's fair to say that one person, I know you have 2 coders, but if there has never been a history of abuse or neglect, police phone calls, things like that, one person's opinion about whether Ethan was neglected could be different than another person's. Is that a fair statement?
No, it's based on data, which 2 people code and then a 3rd person checks.
Okay, and specifically in this case with the shooter, you don't have an awareness of what data was used to make that conclusion.
I don't know.
Ew, achoo. That's fake. Smells like asparagus in here. I don't know if it's possible to have a more boring trial
Let
ever.
me see if I have anything else.
You know what I'm saying? Shit is boring. Shit is
In your
boring.
work, interviewing people who were related to other mass shooters, have you interviewed any persons who said, I knew the shooting was going to happen, or I knew the perpetrator was going to commit this school shooting?
I'm not sure I understand the question.
Have you had any people who know these perpetrators say, I knew he was going to do this before he did it?
Oh, I see. Interviewed people who have said, I was very worried, but not that said, I knew a school shooting was going to happen on this day.
Okay. And in any of those cases that you have looked into with the perpetrators, and I know you said there's only 30 alive, and so it makes it difficult because some are not here any longer. Are there any cases where parents were criminally charged with in connection with the perpetrators in your database?
Yes. Not with manslaughter, I don't believe.
Okay, not with manslaughter, but what crimes?
I believe sort of buying a gun for a minor.
Okay, outside of buying a gun for a minor or violations of state safe storage laws in states that have those, you have not had experience working on cases aside from this one where parents are accused of involuntary manslaughter for the actions of their child.
No.
I have nothing further at this time.
Thank you. Ms. Lena?
Your Honor. Dr. Peterson, I'm going to go back a little bit in your direct testimony with Mr. Keys. You testified, and I'm going to paraphrase what you said, but you testified that you wanted your database and your book and your various studies to be publicly available. Is that right?
Yes.
And the reason that you wanted them to be publicly available was because you wanted to, I believe you said, make a difference.
Yes.
And in making a difference, you wanted to educate people.
Yes.
And you wanted to educate people on what you have identified as the various steps in the pathway to violence.
Yes.
Now, it's your understanding, based on your studies and based on your reviews, that the majority of people don't know what the steps are on the pathway to violence.
True. Yes.
And in this case in particular, you haven't reviewed anything. Ms. Smith went over what you reviewed to write your report. You haven't reviewed anything, weren't provided any information that James or Jennifer Crumbley had ever been advised on what the steps on the pathway to violence are. Is that accurate?
Yes.
And to your knowledge, you don't know that they're even aware of what the pathway to violence is.
Yes.
So it's fair to say that even though you have found that there was a crisis point, you identified, I believe, 2 crisis points with the shooter in this case, you identified that there was leakage in this case, in your opinion. You wouldn't be able to testify that either James nor Jennifer Crumbley knew what those things were, that there were crisis points or that there was leakage and that they should intervene. Is that fair?
I don't think you have to know the term leakage to see leakage and be concerned.
But
Yo, why do they keep saying leakage? Like, what the fuck? What are they talking about?
need to intervene.
This shit is
A common
boring.
person seeing that math drawing, I guess I disagree.
Okay, a common person wouldn't know that that's leakage.
I don't even know what
It's
leakage
cause
is.
for intervention and concern, I would think.
So they might know that it's a problem, but they wouldn't know that it's leakage, that there would be a mass shooting.
Leakage.
They wouldn't know that it was the term leakage, no.
She said leakage again.
You testified with on your cross-examination with Ms. Smith, and I believe also with Mr. Keese, that the data in this case that you compiled and that the Violence Project compiled was based on publicly available data.
Sure.
And specific to this case, you wrote your report, and I believe Ms. Smith asked about an op-ed that you wrote based on what was publicly available.
This report, no.
I'm sorry, this report was based on what the prosecution provided to you.
Correct.
Your opinion that you wrote shortly after the shooting in this case was based on what was publicly available.
Yes.
And is it fair to say that what was publicly available would be what you find on the internet?
No, things that are published in reputable sources.
Okay. So we talked about media reports.
Correct.
And that would also be interviews that you observe,
Correct.
interviews with the prosecutor.
If it was reported in the media, yes.
In the purpose of your research, I think you said that you started with mitigation in the New York Defender's Office and mitigating cases involving the death penalty.
Right. Yes.
And then you moved in 2017. Your path kind of I don't want to say it moved around, but it evolved.
Yes.
And you chose to focus on how to intervene to prevent mass shootings.
Yes.
And that began in 2017.
Yes.
Okay. And so the purpose of your research and your studies since 2017 has been to identify ways to prevent a mass shooting.
Yes.
And I think we covered this a minute ago, and one of the ways that you believe you can prevent mass shootings is by educating the masses.
Yes.
And I believe you testified with Smith that the majority of your education of the masses that you've done personally has been with law enforcement officials, right? And school officials, school administration, people of that nature. Is that fair to say?
Yes.
Okay. You testified that you have done some trainings with parents, right?
Yes.
You didn't train James or Jennifer Crumbley, is that right?
Not that I'm aware.
You haven't reviewed anything in this case, and it's also fair to say you didn't interview a shooter in this case.
No.
You weren't able to independently verify any of the information that was provided to you by the prosecutor's office.
The evidence that was provided to me?
Correct.
Correct.
So you didn't interview anyone to determine whether or not what was provided to you or what's been said about this case was actually accurate.
No, I didn't have that opportunity.
And I don't recall if I asked you this, and if I did, I apologize. You haven't been provided any information that James or Jennifer Crumbley would know how to identify any of the steps on what you've identified as the pathway to violence.
I'm not sure what you mean.
Okay. You haven't been provided any information that James or Jennifer Crumbley, I'll take it a step back, know what the pathway to violence is.
Yes.
That's accurate. You don't.
Accurate.
Okay. And you don't know that they know that there are steps to the pathway to violence.
Correct.
And you don't know whether they were able to identify any of those steps.
Correct.
You acknowledge, I believe you acknowledge with Ms. Smith that there were others who may have been made aware of what the shooter had been planning.
Yes.
Okay. And that would be a friend, correct?
Yes.
And there were school officials,
Yes.
teachers,
Yes.
a number of people who you were able to identify who actually did know what the shooter was planning.
I don't know if they knew what he was planning, but who saw the leakage?
Who saw the leakage? And is
They
it
said
fair to say
leakage.
that, and you may not be able to answer this, but in this day and age, in the age of what you have identified as a prevalence of mass shootings, and I think we agree that there is a prevalence of mass shootings, that school officials, teachers, law enforcement officials, those are people who are more readily able to identify things such as leakage or crisis points or things like that.
She said leakage.
As compared to,
The general public and lay people who have never had.
I would say as compared to family and people close to the shooter, no. But compared to lay people with no training, yes.
It's also fair to say that any review that you've done during your research or your studies, or even the review in this case, everything is done in hindsight.
Yes.
And it's fair to say a lot easier to identify things in hindsight than when they're actually occurring. Is that fair?
That's fair.
Thank you. I have no further questions.
Thank you, Judge. You were asked if any other parents in your study have been charged with any crimes in relation to mass or school shootings. Remember that question?
I do.
And you thought that perhaps no other parents in the country were charged with involuntary manslaughter in the circumstance.
Yes.
Okay, what's different about this case?
The differences in this case are the sheer volume of leakage, the fact that
Leakage.
the parents were called to the school and made aware of the leakage the day of the shooting, and
Leakage.
the fact that, as far as the evidence I've reviewed, they knew that the perpetrator had access to an unsecured weapon.
Now, it's fair to say that anyone can prevent a mass shooting, is that right?
Yes,
Okay, we're not talking about predict, we're talking about prevention.
correct.
Okay, you were asked about that study of 229 law enforcement officials who were shown certain documents and then asked if this tells them a school shooting is going to occur. Do you recall that?
Yes,
Okay. And is it fair to say that those individuals were shown pieces of leakage in a vacuum?
Why do they
Okay,
keep
what do I
saying
mean by that?
the leakage?
it means they saw that piece of leakage and they had no context about the person who made the leakage, their background, their circumstances, their access to weapons. We actually got a lot of pushback from the people involved in that study because they wanted more information to be able to evaluate it.
Okay. So just as your last answer, one of your last answers in the cross-examination was that people close to a shooter, family or friends who have the ability to detect crisis point and leakage, those are the people in the best position to prevent a mass shooting. Would it be true that seeing a piece of leakage in a vacuum doesn't really do a lot of good?
Right. You need to gather as much information as possible, and the people closest to the perpetrator are going to have the most information.
But even those exhibits 4 and 5, even if you just saw that exhibit in a vacuum, does that indicate something that should be done next to you?
You know, looking at this specific piece of leakage in a vacuum, I would say this would be high risk in any circumstance.
So when you look at that exhibit in particular, if there is somebody to view that particular exhibit who also knows that the person who drew that picture has a firearm that looks identical to that firearm, who also begged for that firearm, who knows how to use that firearm, and received that firearm just 4 days prior, that's information only known to that person, correct?
Correct.
So that's all information in a context would be pretty important to you.
Yes.
Okay, and you don't need to actually understand the definition of crisis point or the definition of leakage to know it's time to intervene.
Yes.
Okay, so you're not going to testify that you need a PhD to stop a school shooting, right?
No.
Why?
Anyone can stop a school shooting. If we see leakage, if we know there's access to a weapon, if we know that a young person is in crisis, that's the time to intervene.
Now, you were asked about how you gather your data and how the Violence Project was formed, and it relied in part on open sources.
Yes.
Okay, and tell me about the practice of using open sources in studies such as mass shooting prevention.
Open sources are a very common methodology to use, and in fact, there's been studies to show that open sources are sometimes more reliable than FBI files just because of what actually ends up getting reported. So there's limitations to open sources, but the goal is triangulation. So you take as many pieces of information as you can coming from a combination of primary and secondary sources and try to make sure whatever you're reporting is valid from a number of different sources.
Okay, and the fact that mass shootings, in particular school shootings, are very heavily reported, does that give you a little bit of reassurance when you look at a media report?
Yes, so one of the reasons we chose 4 More People Killed is because those are the shootings that get a lot of media coverage, so you can get a lot of information.
In the Violence Project database, you indicated that you may enter an event, but you go back and you check the data over the next 2 or 3 years.
Yes, we know that the best data comes 2 or 3 years down the line after a trial has come out or after an FBI investigation, so we do continually update the data.
Now, you were asked a question about the antidote in your book regarding a potential school shooter who was given a pie, and that small act of kindness, that changed that pathway to violence.
Yes.
So it's your research, your findings, that even something small can prevent a school shooting?
Yes.
Especially if somebody knew about Crisis Point?
Yes.
And knew what was going on in that person's life?
Yes.
Nothing further.
I usually would not allow recross, but if you have any remaining questions, I would allow that.
No, Your Honor, I do not. Thank you.
Anything further?
Nothing, Your Honor.
All right, you may step down. Thank you. Does anybody need a break before I ask for clients? Does anybody need a break before?
Yeah. Let me just get a quick bathroom break for them.
Okay. All right. So, I'm gonna ask everybody to remain seated, please. All right. We're gonna take a brief recess, 10 or 15 minutes, okay?
Oh, this shit is boring. It is boring. Hey, look! Like one of our Facebook viewers said, a defense attorney is wearing... Does that look like a defense attorney? No, it doesn't. Tell you what I'm gonna do. I'm gonna fuck off. From now, I gotta bring a bunch of shit to the post office. And then, I'm gonna go home and... Oh, actually, I gotta go to the store. And get a TV from there. And then I gotta go to the CVS to get my kid's prescription. Then tonight, we're gonna do the Fucking About Friday. So, which, what should I call it? The Fucking About? Like Canadian? Like Fucking About Friday. That's only gonna be live on the Angry Tulips Turnip, Angry, what the fuck is my name? Angry Turnip's Facebook page. Or YouTube page. Well, I can't even fucking talk anymore. Yeah. So, I'll be live 8 p.m. tonight. That'll be a call-in show. And yes, I will be doing the entire call-in in this voice. Why? Because I can. And it's funny. And if you don't like it, nobody cares. Paul Pelosi was attacked by a man with a hammer. They're not putting out any information outside of that. So you can only assume that, well, but and that Paul Pelosi's expected to be fine. So you can assume that they're going to say that he was a Republican or something like that did the attacking. You know it. You know it. You know it. You know it. And Margaret, I never called you a liar. You just got to provide a little bit more information into your fucking emails, please. Thanks. Yeah. Yeah. What else? What else? Boop, 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 doo. Skibbity, boop, doo. Sounds like a Canadian leprechaun. No, it doesn't. You sound like a Canadian leprechaun. You sound like a Canadian tree frog. You know what that sounds like? Neither do I. That's what you sound like, though. Yeah, so tonight's show is going to be a little bit different. Okay, it's going to be goofy. It's going to be fun. We don't need to just talk about politics. We can talk about anything. It's a call-in show. You can talk about whatever the fuck you want. But we're not going to talk about stuff that I don't want to talk. Fox News said he was severely beaten by the man. Yeah, the man had a hammer, so that's likely going to happen. But yeah, hopefully he's going to be okay. From what I understand, he's going to be okay. And we're talking about Paul Pelosi. Paul Pelosi was attacked with a hammer by someone who broke into his house. But it's weird because some of the news articles said that he wasn't, or they said that it was a gunman and that he was attacked with a hammer. And where the fuck was Nancy? Huh? How come Nancy Pelosi wasn't there? She was out of town as well when he crashed his car into another car. Remember that when he was drunk? Yeah. So we'll likely talk about that. We'll talk about all that stuff. You know? Angry Donut said so. A normal show then? No. All right, guys. I'll see you tonight, 8 o'clock Eastern. Bye.